The Honourable David Parker.
Thank you, Mr Chairman. I have to say that shortly after the House had risen at the end of last year, it wasn't the most thrilling news that I had to sit for 3 days on Select Committee in Christchurch to look at the Greater Christchurch Regeneration Bill. But having been somewhat less than thrilled to get the opportunity, I actually enjoyed the experience in the end. Because I thought that the information that the submissions that the submitters brought forward were heartfelt, they were well considered, and I thought the committee, well chaired by Scott Simpson, sorry Scott, by Scott Simpson, memory blank there. I thought that we did do justice to the submitters, many of whom were giving up in the end their weekends because we continued to hear submissions on the Saturday morning. The theme that was clear to me, which is expressed in this part 2 of the bill, was that as we transition from the state of affairs post-earthquake back to normality, there was a need for a gradual transfer of power back to the city. Of course, after the earthquake, this Parliament under urgency passed legislation which effectively took away from Christchurch City control of the aftermath of the earthquake and gave very wide regulation-making powers to the Minister to take over essentially any function that the Minister thought was necessary to take over at a central government level in order to pursue the recovery after the earthquake. I think overall the Minister has exercised those powers sparingly, and that whilst the powers that were granted by Parliament were very wide, in fact probably too wide, the Minister has been responsible and not sought to garner too much power to himself. Having said that, the form of the Greater Christchurch Regeneration Bill that came to the Select Committee and was submitted upon by submitters was seen by many of the Christchurch, Canterbury I should say, not just Christchurch but also Kaiapoi affected, was seen as being broader than was necessary and was, paternalistic is probably the wrong word, but didn't sufficiently devolve back or begin to devolve powers back to Christchurch City. Now, Christchurch City is not a small council. It's one of New Zealand's largest council. It's got a large staff and a lot of very competent people. And so I was one of those who thought that perhaps the Mayor and other submitters had something when they were saying that too much power was being retained by the Minister as to what would or would not be done by Regenerate Christchurch. The point was well made at Select Committee that Christchurch can't spend the government's money. If the government's making contributions to things, then those contributions are either bound by other deeds that have already been entered into pursuant between central government and local authorities, or they were uncontrolled or unspecified spending by the government, which of course it can control by refusing to spend it. So it wasn't a matter of who controlled the purse strings, because the government always does. Central government always does in respect of central government's money. No one else can force central government to spend central government's money. I thought that the amendments or the proposals that came forward from Mayor Leanne Dalziel and others were reasonable, and I had expected that they would have been put into the bill by the Select Committee, and I was somewhat surprised to learn that by the time the bill came back to the House, some of those amendments had not been made. Having said that, I'm pleased that the Minister has seen sense, because I don't blame the Select Committee for that. I'm sure that the government members had at that stage, I'm not implying any wrongdoing here, but had a Minister who wasn't yet willing to make those changes. The Minister, through consultation with other parties and perhaps members of his own party, came to the view that it was proper to move further, and part 2 is where we do that. And the description in the explanatory note to the supplementary order paper, which includes the alterations to which I've just referred, makes it clear how Regenerate Mr.
The Honourable David Parker.
Chairman, makes it clearer that Regenerate Christchurch, which is an amalgam of officials or an amalgam of people from both central government, Ngāi Tahu and the City Council, that board now has an enhanced role, and effectively the ministers' roles are truncated by the additional roles that are given to Regenerate Christchurch. And I think that the Parliament can be pleased that they've got to an outcome that parties on all sides of this House can agree is a fair enough compromise. My understanding is that the Christchurch City are happier with this than they were with the prior provisions. I will say one other thing, sir, and that is I think that we do now need to learn the lessons from the Christchurch earthquake more broadly in respect of what powers we should take off local authorities and what powers we should leave with them. I think some of the broad regulation-making power that this Parliament voted for, and I was one of those that did vote for it, were broader than they needed to be. The ministerial powers of intervention and regulation-making powers went further than was necessary. I know that, again, the same select committee was at one stage hearing the Regulations Review Select Committee was at one stage hearing submissions as to what lessons we could learn for the future, whether there was some form of legislation that could apply in all future national disasters, where there could be some sort of menu from which regulatory powers could be drawn. There were some, including me, who was a bit suspicious that that went too far. That was effectively saying in advance we'll give carte blanche to ministers in the future to override a lot of legislation which might not ordinarily need to be overruled and shouldn't give those general discretions to override acts of Parliament if you don't need it. Given that these events are pretty rare, I think that there's always a case when you have a national disaster of the scale that we did in Christchurch for Parliament to pay particular attention to it and to pass specific legislation in respect of that event if it's necessary. So I hope that the benefit of the experience in respect of the Canterbury earthquakes is next time something like this happens, we know what powers are likely to be needed by a minister to override normal statute law and to override normal City Council powers, and we can be more specific as to the powers that we give to the minister in respect of that post-disaster phase, and also that through this now modified Greater Christchurch Regeneration Bill, we've got to the right sharing of power as between the minister and the city.